Welcome to the Courtroom Chronicles. This channel is dedicated to educational content based on real-life cases and true events. This content shared here is drawn directly from the actual case file, and no names, places, or items have been changed. However, the content has been carefully summarized and presented for educational purposes in a comprehension format to inform, enlighten, and spark meaningful discussions. Whether you're here to learn, reflect, or simply understand the real-world scenarios better, you're in the right place. We believe in the power of truthful storytelling to educate and inspire. Disclaimer: while all stories are based on real cases, they are presented in a condensed and structured format for clarity and learning. Viewer discretion is advised where necessary. This case is cited from the Nigerian National Industrial Court online file, which is public record. A man named Mr. Adebayo Bamigboye, who was pained and felt mistreated, walked into the courtroom, files in hand, heart-burdened with a sense of injustice. He was once an employee of the well-known United Bank for Africa Plc, UBA, until a letter dated 20th December 2019 shattered his professional footing. That letter terminated his employment, and Adebayo believed it did so wrongfully. In the eyes of Mr. Bamigboye, this wasn't just a job lost, it was a violation of principle. He argued that the bank had breached the terms of his employment, specifically pointing to the UBA staff handbook, a document he considered sacred in the employer-employee relationship. He told the court that the termination didn't follow the procedures clearly outlined in the handbook. He had been accused, without proof, of fraud or misconduct and wasn't allowed a proper defense. No fair hearing had been granted. The internal memo used to recommend his exit was flawed, possibly tainted with bias. The bank, however, had a different tale. UBA's defense was confident and structured. They told the court that Mr. Bamigboye's termination stemmed from gross misconduct, and they had conducted internal investigations to reach that decision. They had followed all protocols as specified in the staff handbook, ensuring fair hearing. There was no breach of contract. Instead, it was a textbook disciplinary process. The courtroom atmosphere thickened as the judge delved into the case, inspecting every clause in the employment agreement, especially the often cited staff handbook. And then crucial moments unfolded during cross-examination. Mr. Bamigboye, under pressure, admitted he received a query from UBA and he responded to it. That confession changed everything. The judge noted, fair hearing doesn't require a courtroom setup. Simply being allowed to respond to allegations can be enough. There was no evidence from Mr. Bamigboye proving that the bank's procedures weren't followed. The internal memo, which mentioned other staff, was not the dismissal letter itself, and hence posed no legal issue. The gavel eventually fell in favor of UBA. Why did Mr. Bamigboye lose? He failed to prove that UBA breached any part of the employment contract. His own admission of receiving and replying to a query confirmed he wasn't denied fair hearing. He didn't produce any documents or strong evidence to counter UBA's defense. The court ruled that the dismissal was lawful, particularly because UBA had demonstrated a case of misconduct. Lessons from the case. This case carried more than just legal implications. It offered deep insights into workplace dynamics. Transparency matters. UBA might have avoided litigation by clearly documenting and communicating the disciplinary process. Knowledge is power. If employees are well-versed in their rights and responsibilities through training on internal policies, misunderstandings can be prevented. Alternatives to court exist. Mediation or internal grievance channels might have resolved the dispute without the stress and cost of a legal battle. Legal advice is key. Mr. Bamigboye might have reconsidered his case had he consulted a lawyer earlier. The takeaway. In employment law, contracts reign supreme. If you're going to claim wrongful termination, you need solid proof that the employer violated the agreement. And remember, fair hearing doesn't have to look like a trial. It just means having the chance to be heard. Thanks so much for watching, fam. I really appreciate you spending your time with me. If you enjoyed the content, don't forget to hit that subscribe button, drop a comment below, and let me know what you think about the case. I love hearing your thoughts and feedback. And hey, if you felt a connection or learned something new, give this video a like and share it with someone who might enjoy it too. Until next time, stay safe, stay real, and I'll catch you in the next one.